speech power.
Before lunch, I've made the submission that actually the ultimate question is the real cause of homelessness. It needs to be addressed in a practical and common sense way. But it is going to be fact sensitive depending on the facts of each case. So briefly we look at the facts of this case. This was a case where the applicant had been occupying 22 Church Road in performance of the main section 193 duty. And I say that is a significant feature. The private landlord serves a notice in November. But I also say it's a significant feature of this case that the appellant knew that actually he would not be made homeless as a result of that offer, because Bromley told him almost immediately it still owed the section 193 duty towards him and that would make him a suitable offer before the notice expired. The offer was duly made. It was made on the 14th, so before the notice expires, and it advises the applicant as a consequence of refusal. There's no issues about any of that.
Sorry, can I just understand one point? This is for my benefit, probably shows my lack of knowledge of this. While he's in Church Road, he's not factually homeless.
That's right. Well, he's in.
So when you say the housing duty is still owed, is it the same?
It's the same main section 193 duty. So while he remains in Church Road, all the housing duty in fact remains until it's discharged.
Is that because of it's a temporary accommodation?
That's right.
Oh,
that's right. That's absolutely right. So quite often people are sort of accommodating stages, they call it, and it might be temporary accommodation, it might be for long periods of time, but a local authority can only finally discharge duty on making what we call a final offer, an offer under Part 7 or an offer in the private sector that complies with the requirements of Section 193. So for these purposes, Bromley remain under the duty all the while he's in Church Road.
Thank you.
And
Sorry, when you say make an offer under Part 7?
That's right. They make him another offer. They make him an offer pursuant to their main duty, because they're still under the main duty. They make him an offer of temporary accommodation elsewhere.
I see what you mean, yes. Yes, I see. But the duty will only come to an end if various things happen, including making a Part 6 offer.
That's right.
Yeah.
Or if an applicant has made a temporary offer and refuses a suitable offer,
Yes.
as has happened here.
Yes.
So the notice is said to expire on the 15th of January, but in fact, the 15th of January comes and goes. The appellant doesn't leave then. He's still in occupation. And we also know from the facts that Bromley extend the date by which he needs to accept the offer. And he's advised again, this is your final offer. No further offers will be made, and present accommodation may be cancelled. So it is all there for him. We then know what happens is on the 19th of January, Bromley then do discharge their duty. And when they discharge duty, the appellant is still in occupation of 22 Church Road. So the appellant cannot assert now, and in fact doesn't attempt to do so, that there hasn't been a valid discharge. He's precluded from that because we have a problem. Once that duty, the Section 193 duty, is brought to an end, the main duty, any further offers of accommodation are only going to be under discretionary powers, so it won't be under a duty, but of course they do have discretionary powers still. One of the discretionary powers to accommodate is to keep accommodation open pending a review, so if somebody seeks a review. So there are still discretionary powers to continue to provide accommodation, and that's what Bromley did. And in fact, we also know that Bromley themselves don't actually cancel their nightly let with a landlord provider until the 26th of January. We get that from the supplemental bundle at page 30. So Bromley send a cancellation request to Crest Manor on the 26th of January, saying the last night of occupation is 25th of January. fact, we also know that Bromley do tell the applicant, you can't stay there, the landlord wants the property back, so we're going to give you something else using our discretionary powers. So the first point I make in relation to that is one of the things that the claimant asserts is he left in compliance with the notice. Well, factually, that's not quite right, because the notice expires on the 15th of January, and he doesn't leave in compliance with the notice. He leaves later. He leaves on the 19th, and we know he leaves on the 19th because we see Bromley make him an offer of other accommodation.
So we have to assume that he moved
I think that's the right. I think
at the date he's offered this Sutton accommodation.
yes. And I don't believe that's in dispute, but I think that's the only sensible analysis when one looks at the email, which is at page. It's SB 28, which I think is when the offer's made.
I think that's the way the judge deals with it, what it's worth.
Right. Okay. I mean, I believe that's right. Either way. We know for certain he doesn't leave on the 15th because he's still there. It looks like it's the 19th, but it probably doesn't. A great deal doesn't turn on that. But in answer to the appellant's central plank and their main proposition of law. Their main proposition is the only finding Sutton could make is that the appellant wasn't homeless intentionally. And in fact, that's the finding the appellant now invites this court to make. And I say, as a matter of principle, that's wrong because it's for the local authority to be satisfied. It's for it to make a decision. The court supervision or jurisdiction in these cases is obviously it's a public law jurisdiction and has a local authority behaved when it's been unreasonably or made an error of law, but it's not for this court to substitute its findings of fact. So we then look at the findings that this authority made, and if I could take you now to the review decision to do so, and that's in the core bundle at 110. And what the respondent says are actually the core findings. Well, first of all, at page, if I take to 110, one of the criticisms is made is that the respondent didn't deal with causation or sidestepped it. Well, I say no, if you look at the decision, if I ask you to look at the last paragraph on 110, the penultimate sentence, the effective cause of your homelessness was the refusal of a suitable offer, but for which you would not be homeless. So I say causation is dealt with head on. And then turning over the page to 111, reasons ceasing to settle last accommodation. It takes into account, under the second paragraph, Bromley Council, it takes into account the fact that actually Bromley did receive a notice the landlord wanted the property back, but also that Bromley informed him another offer of temporary accommodation would be made. As a result, Bromley discharges its duty. And then the core finding was this decision of yours to refuse this offer, which was the operative cause of you becoming homeless, as Bromley Council would have had a continuing duty to secure you with suitable accommodation. It does take into account, in contrast to sort of some of the cases where local authorities have criticised, it did take into account the fact that the landlord's notice had been served, but it finds that wasn't the substantive cause of your homelessness.
I mean, one trouble with that sentence is that arguably it looks like the way the judge was looking at it, not saying the operative cause of you losing this accommodation, but the operative cause of you becoming homeless in a broader sense.
Yes, I take your lordship's point, but I think the answer is when one reads the review decision as a whole, it's clear that the last settled accommodation being considered was 22 Church Road, and you get that throughout the decision. In fact, I would say. And I think the other point I'd make is, of course, I'm making this point. The court will be filling me these arguments, but obviously local housing officers aren't judges. They won't express themselves with exactitude, but do we know what the finding is from the review decision of core findings? And I said, well, yes, we do, and in fact, even the appellant acknowledges that the core finding is the operative cause of your homelessness was your refusal of this suitable offer. So reading on from page 111 of the decision, it goes on to say 22, so I'm looking at the penultimate sentence of the last paragraph of page 111, 22 Church Road, so an answer to your Lordship's point, it appears there, continue to be available for your occupation until such time as Bromley offered you a reasonable alternative offer of suitable accommodation in performance of its duty. Bromley made you an offer of 357 Brighton Road, and had you accepted that, you would not be experiencing this current episode of homelessness. So I say that's a perfectly lawful approach in accordance with the law.
I mean, I'm not quite sure what it means. Continue to be available until such time as Bromley offered you a reasonable alternative. Now, they actually made an offer of Brighton Road before even the 15th.
Mm-hmm.
Well, plainly the accommodation was available at that stage.
Mm-hmm.
If, on the other hand, they mean that Church Road was going to go on being available beyond that,
Mm-hmm.
What's the basis for that?
I say what that finding is that Church Road, this sort of feeds into ground two, but Church Road was available and reasonable for you to continue to occupy for so long as you had to do so while Bromley was performing its Section 193 duty towards you. So
yes and no. I mean, supposing that, well, I'm not sure this is relevant actually, but supposing that Mr. Cifci had accepted the offer,
mm-hmm.
and then the property had been found not to be suitable,
Mm-hmm.
Well, he still couldn't have gone back. Even though you wouldn't have performed your duty.
Save that he wouldn't be homeless, he wouldn't be experiencing an episode of homelessness because he's accepted the alternative offer, so he's now living in there. So that's not caused his homelessness. And then if he has a review, it either goes his way. If it goes his way, Bromley remain under the duty. If it doesn't go his way, he's still where he is, but he's not homeless.
No. Just going back to the sentence. Church Road continued to be available until such time as Bromley offered you a reasonable alternative. Well, if Brighton Road was a reasonable alternative, that's true.
Mm-hmm.
If it wasn't,
Mm-hmm.
it's not true.
I think the answer to that is, and this really takes to a sort of second ground of appeal, which is reasonable to continue to occupy, is for how long does that have to be? And in my submission, it doesn't have to be indefinite or anything like that. And I get support for that in the House of Lords case, in the case of Valley and Birmingham, and perhaps now's a good time to look at that.
Yeah.
So that's in the authorities bundle at, I'm afraid this one appears twice, it's so good we put it in twice, but if I take you to where it appears first, which is at tab 3, page 30. So my lordships might be familiar with this case. This is one where a woman had been accommodated in a women's refuge, and it's whether or not, first of all, whether it's accommodation, but actually they said they answered it by looking at what is meant by reason to continue to occupy. The passage I'd ask the court to look at is at page 30. sorry, not page 30, it's at page 42. So it's paragraph 42, C to D. So I'm giving you the page number, so it's going to be page 44. So what they're looking at is the full housing duty, and in this case, by provision of temporary accommodation. Emphasise that, so this is about halfway down, emphasise that accommodation which may be reasonable, unreasonable for peer to occupy for a long period may be reasonable for him to occupy for a short period. Accordingly, there will be cases where an applicant's accommodation which will not be reasonable for him to continue on a relatively long-term basis would be for him to do so if the authority did not accept him as homeless, but it wouldn't be unreasonable to continue for a short period while the authority invests his application and rights, and thereafter will they look for accommodation to satisfy their continuing section 193 duty. So I say this is effect what's happened here. Bromley know that the landlord want the property back, but they're still under a duty, and they perform that duty by looking for suitable alternative accommodation. And so it remains reasonable for Mr. Cifci to remain there when we continue to perform the section 193 duty. Also relevant to that point is paragraph 46 of the same judgment while the court has it open. So that's looking at the meaning of reasonable to continue to occupy. And it makes the point that you can find it's reasonable for somebody to occupy property for a little while longer. And it's reasonable for them to continue to occupy the accommodation for as long as he or she will have to do so unless the authority take action. So if we look at the facts of this case, let's
Sorry, there's a knot in there which you didn't read out. Just trying to find this.
If it would not be reasonable for the property to continue to occupy the accommodation for as long as he or she will have to do so unless the authority take action. So, my lady, I think the point being made there is if a local authority aren't doing anything about the person's situation, and let's apply it to the facts of this case, if a no duty had been owed to the appellant and a notice had been served and nothing was going to be done to help him, it might not be reasonable for him to continue to occupy. It will depend on the facts. But on the facts of this case, we have Bromley looking to fulfil its housing function and find some alternative accommodation. So the question for how long somebody can reasonably continue to occupy is again a matter for authority. And in fact, what Ali goes on to say, it appears at paragraph 50. The approach to be adopted by a court, paragraph 50, when considering the question whether a local housing authority have left an applicant who occupies accommodation which it would not be reasonable for him to continue to occupy in that accommodation for too long a period. The question, of course, is primarily one for the authority, and the court should normally be slow to accept that the authority have left an applicant in his unsatisfactory accommodation for too long. So if Bromley hadn't owed a duty, well, in fact, there's a number of things that would have happened if the appellant's case is that actually the notice is the only cause of homelessness. Let's leave Bromley out of the equation, and let's assume he was just in privately rented accommodation and no duty was owed. When the notice is served, he doesn't become homeless in consequence of the notice, but he might be threatened with homelessness. So there is a distinction there. And in fact, the court was taken to paragraphs in the Code of Guidance dealing with whether it's reasonable to continue to occupy when a Section 21 notice has been served. But the first point I'd make is, well, that's quite a different set of facts, because that's talking about Section 21 notice. But also the crucial distinction there is a person might be threatened with homelessness, and it might be then a different duty applies, for instance, the prevention duty. So it might be a notice is served on an applicant in private accommodation. They then become threatened with homelessness. That's Section 1754 of the Act, if the court needs to go to it. And if they're homeless and eligible for assistance, other duties then kick in. One of those is prevention duty. So what might then happen is the local authority might try and keep the applicant in that accommodation. They might negotiate with the landlord, or might be with a private family. It might be they've been a notice is served. They were living with their parents. They might then negotiate with the parents. Say, can you keep them there for any longer, or can you withdraw the notice? That's, on this case, I say what happened is, Bromley, because they were under a duty, a continuing Section 193 duty, were looking for alternative accommodation, alternative suitable accommodation. So he wasn't becoming homeless. He knew that he wasn't going to become homeless on the expiry of the notice, because he already knew Bromley were looking to find other ways to assist him. And then insofar as the appellant asserts you can't be intentionally homeless in these circumstances, well, I say there's a whole raft of court authority that says, well, actually, you can. If you've refused a suitable offer, you might find yourself up against a finding of intentional homelessness. The first case is Godson, to which you've already been taken to.
Sorry, just before we go on, while he was in Church Road, he wasn't, although the duty was still owed, he was not actually homeless because he had that accommodation.
And I would say, actually, sorry to go on further, I'd say he wasn't even threatened with homelessness at that stage.
Right. When he, just looking at the facts, when he does leave, he goes to a property in Sutton, available, it's said, for 28 days. While he's in Sutton, is he homeless?
I think the difficulty with the Sutton accommodation is, I think that was, I'll check, but I think it was under section, they offer under section 188. I think, if I'm right, if it's under section 188, it would still be, there wasn't a fresh application.
It's a jury number 5 applicant.
I see.
So it's section 188 and 200.
That's right. So I think 200 is to do a local connection referral, so I think that might be the mistake with Romney's letter.
Sorry.
I just want to avoid some timing waste on something
Yeah.
which I think could get confusing. There's no question of any fresh application having been made at that point. If you're talking about accommodation in the High Street,
Yes.
that was so described as discretionary because of the case law, which is established, frankly, for decades, that if you terminate a duty, as happened here, you're unlikely to be acting reasonably if you say tomorrow you're out.
No, I understand that, but I'm
There's no
actually
statutory
asking a different question.
So
Is the individual homeless when they are physically moved to the Sutton property? It may be a complete hair running inappropriately,
No.
but I just wanted to try to understand that point.
yeah, I would say he becomes. Well, I think we might end up in a section because I think we would then have the same argument as whether it's reasonable for him to continue to occupy that new accommodation, because that was only ever available for 28 days. So I think it would be the same homelessness. So he becomes homeless from Church Road. I think if we were to look at this other property, we might find we're back to the same arguments about whether it's reasonable for him to continue to occupy that one because it's only been made available for 28 days. Does that answer your question, my lady?
I understand what you're saying, because you are homeless if it's not reasonable to continue to occupy.
Yeah.
Thank you.
So the fact that Church Road wasn't going to be available indefinitely once the notice was served, I say the facts of this case doesn't actually matter because it was available and it was reasonable for him to continue to occupy whilst Bromley investigated his application and made him another offer. And I say I get further support for that proposition in the case of Carly and Coventry, or Carlin Coventry rather. So that's in the authorities bundle at page 105.
Tab 7. Tab 7.
Tab 7, thank you. And if I can ask your lordship and your ladyship to turn to paragraph 42
119.
at page 119. I know it's a case that the court will probably be familiar with, and your lordship drew together threads from previous authority looking at cases like Arwar and Aries and Morgan, which is the Birmingham Alley case. And at paragraph 42, drawing those threads together, there's no need for accommodation to be so bad so a person couldn't be expected to stay there for another night, but a person doesn't have to be entitled to remain in the accommodation indefinitely or for any particular period of time for it to be reasonable to continue to occupy. And neither need it be accommodation reasonable to continue to occupy forever. A person will not be homeless if there is accommodation which would be reasonable for him to continue to occupy over the period which would elapse before the local housing authority rehouse him. So that's the first point I rely on. And the second point, physical characteristics will often be of central importance. Also restrictions affecting a person's life. It goes on to say possibly the length of time a person has to remain in accommodation may sometimes be of significance, but it's much less likely to matter. So what I would say in relation to the landlord's notice, the property still remained available beyond that point, still reasonable to occupy, because Bromley was still performing its section 193 duty, because they had to find the applicant something else suitable.
Well, yes, but where does that take you? You say it's reasonable to occupy while Bromley do what they're supposed to do. They then do that, and let's focus on the final offer. They offer alternative accommodation again on the 17th. How does that answer the question that we're being asked to address, which was whether the local authority were entitled to conclude that the reason he actually left the property was because he had to?
I say the reason the local authority is entitled to make that finding and this court should uphold it is because if there are multiple causes of homelessness and the notice might have been a potential cause, it's enough to identify one cause. and this is someone who wouldn't have experienced, and this is what the Act is all about, so it's back to the purpose of the Act. This is somebody who would not experience his current state of homelessness had he accepted a suitable offer. He wouldn't be experiencing this episode of homelessness.
And that's obviously true in a general sense, and has a force to it. Mr. Burton says, well, that's all very well, but let's go back to the wording of section 1911, and we have to look at why the person ceased to occupy this property, which is different from why he became homeless in a more general sense. So why did he cease to occupy this property?
Exactly. I see the point straight away. But what I say is it should be addressed in terms of, well, there are potentially multiple causes. The landlord's notice may have been a cause, but it's never acted upon, and we know that. The reason there was never any need for it to be acted upon was because Bromley had made another offer.
Well, that's not factually true. I mean, the landlord presumably didn't act on it because the family left.
Yes, that's absolutely right. But the reason the family left was because it comes back to the fact that Bromley had made an offer which had been refused and duty discharged, and then they gave him a reasonable notice period in another property. But I said that doesn't negate the fact when one approaches this from a common and practical sense way, and I said that's what the court should do when looking at issues of intentionality. What substantially caused the homelessness? And I say it comes back to the same point, that actually had he not refused the offer, or had he accepted it and then requested review, he wouldn't experience this period of homelessness.
And in a general sense, that's obviously true. But if the question is, why did he leave this property? Now, Mr. Burton says, well, he left the property because the landlord wanted it back, and Bromley, which was providing him with accommodation, said it needed him out. And it said they needed him out even in circumstances where they said, well, if things had been different, we'd have left you there for 28 days. So that's Mr. Burton's case. How do you get to the conclusion that his leaving the property was caused by his refusal of the offer?
Because even after the notice expired, he remained there and it remained available for him. And I say reasonable for him to continue to occupy while he considers the offer made by Bromley.
Yes.
Bromley then extend the offer, and then we get to the 17th of January, I think I've got the date right, we get to 17th of January, where he's still saying he won't accept the offer, and then Bromley discharge.
And I follow that. So his refusal is the reason why the duty is brought to an end. Why did that cause him to leave?
Because he had another offer of accommodation made to him. So we go back in time, if you like, before he actually leaves. An offer of accommodation is made to him while Bromley still owe him a duty, and then Bromley discharged the duty. But looking at it in a practical and common sense way, well, why did this all happen? Why did he leave, and why was he no longer owed any further duty? Well, in a common and practical sense, it was because he'd refused a suitable offer.
Well, another way of looking at it, which is why I keep asking about the temporary 28-day property. He could leave in various different circumstances. He could leave because the bailiffs, the possession order is obtained. We're not in that scenario. He could leave to go to the property that he was offered, or closer to the current facts, he leaves the immediate circumstances of his leaving are to go to a property in Sutton, a property which has only been made available to him because the main duty has been discharged, as I understand it.
Yeah.
So the factual circumstances of his leaving,
Mhm.
to the extent it's relevant to see where he goes,
Mhm.
are that the duty's been discharged and he's being offered something on a discretionary basis.
Mhm.
Because some of this seems to be revolve around looking at the sort of quality of what's happening around the cessation of occupation
Mhm.
and whether it's the landlord actually kicking the family out or whether it's something else.
Yeah.
Because no one seems to argue or suggest that there's and it wouldn't make sense to suggest there's homelessness if the offer of alternative accommodation had been accepted.
Yes, that's true. Had it been accepted, he wouldn't be. Yeah, he wouldn't be experiencing this episode of homelessness. But I suppose it comes back to the
Which is
point.
actually related to why I was asking what the quality of that replacement accommodation was, in the sense of whether there was homelessness at that point.
Mhm. Mhm. Well, it's discretionary accommodation.
Maybe no licence.
Yeah,
Or is there some form of licence? There must be.
there must be some form of licence, a short 28-day licence, it looked like. Certainly no security of tenure. I mean, not that would, you could still be homeless even without security of tenure. But I think it would still, come back to looking at reading section 191 as a whole to discern its true meaning. So I don't dispute that, you go through the exercise of looking at the individual parts. I don't dispute that for a single minute because that gives you the focus. But actually, you then have to draw it all together at some point to give it purpose and give it meaning. And the reason I say the respondent's approach is not only Wensbury reasonable, but also consistent with the scheme of the Act, is because on the appellant's analysis, it would preclude a local authority from ever making a finding of intentional homelessness if a landlord's notice has come first in time, if you like.
Then you really need, I mean, you very helpfully this morning, just before the short adjournment, took us to the case of Watchman.
Mm-hmm.
And there the court was very clear to look at what the effective cause was. And there, I think you took us to paragraphs 18 and 20, but in paragraph 17, the court introduces the point. The court needs to be cautious in dealing with causation questions. You're not looking at the chronologically immediate or proximate cause.
Mm-hmm.
The closest in time will not always be regarded as the effective cause.
Yes.
Now, had the notice not been served on Mr. Cifci in this case, none of this would have arisen.
No.
So is that not the effective cause?
No, I say the effective cause of the notice was for Bromley to make another offer. I mean, that was the real cause. If we're talking about causation, what the notice did was to prompt Bromley to make a suitable alternative accommodation. That was its real cause. And I do say the respondent's approach is far more consistent with the scheme of the Act itself, because what the appellant advised the court to do is effectively rule that if a landlord's notice, if it's a private landlord's notice, although I'm not sure it would make any difference who the notice came from, but if a notice is served for whatever reason and somebody has to be moved, on the subsequent application, any local authority is precluded from finding that somebody has been left themselves in a condition of being intentionally homeless by refusing a suitable offer. And that cannot be right. Not only does it end up in the result where actually there is no incentive for an applicant to accept a suitable offer, they might as well hold on reapply the next day and get another offer, and that will just continue indefinitely. So that can't be right for that reason. I also say actually it would have quite significant resources implications too if an applicant can refuse a suitable offer, apply the next day, but actually there's no consequences from refusal. Duties discharged, yes, but they just simply reapply the next day, it could be, and a duty has to be accepted again, and a local authority is precluded from finding, well, actually you're intentionally homeless because a notice was served, somebody was still under duty, and they made you an alternative offer, it was suitable, and you didn't accept it. The dog chases its tail almost, I say, and I say that's why that analysis just cannot be right without doing massive violence to the Act.
And to escape that, you have to find some answer that doesn't just work on the very particular facts of this case, but some answer that works more generally.
Mm-hmm. Well, I say there was nothing wrong with this authority's approach to the question, saying to itself, yes, we recognise a notice was served, but we say that wasn't the operative cause because actually, even after that notice, your case is you left in compliance with the notice. Well, that's factually not right because the notice expires on the 15th and you're still there. So the property, Church Road property A, is still available, and there's no real arguments about that, so I don't really need to take your time on that. It's still reasonable for you to continue to occupy while Bromley perform its duty towards you and fulfills its functions and its duties towards you. Of course, we might be in a very different position if Bromley didn't owe any sort of duty. If this was just somebody who was in a property and through no fault of their own, a notice is served and possession order is made, that would be a wholly different set of facts, but that's not these facts.
Sorry, the difference is because there was a duty, there was an offer of an alternative accommodation.
Yeah.
On different facts where this is just a landlord and it wasn't temporary accommodation, they could be homeless.
They could be homeless. I mean, there'd be a number of sort of steps, if you like, to get there. First of all, the property is still available even though notice has been served because they've got a right to occupy, no court order has been made, but they might end up being threatened with homeless, so the prevention duty would kick in. Or let's say a notice is served because somebody can't afford to pay the rent. Is it reasonable to leave them in that property if they can't afford the rent and the rent is mounting? Is it reasonable for them to have to face possession proceedings, potential costs of that? So then they make their application to the local authority. And I can well see in the example I just gave you, a local authority finding it wasn't reasonable to continue to occupy because you were just generating more debt. But that's not these facts. If I can just turn my back for a moment. No, I think that concludes my submissions unless you have any further questions for me.
No, thank you very much, Mr. Gooch-Powell. Mr. Best.
My lady, my lords, you won't be surprised to hear me say that obviously we do need to take a disciplined approach to the provision itself. In my submission, it is instructive that my own friend repeatedly came round to the same phrase, operative cause of homelessness, as did the reviewing officer below. And it's because of that seductive fact that if it weren't for the refusal of the offer, it may well have been the case Mr. Cifci wasn't homeless at the date of the application to London Borough of Sutton. But of course that doesn't matter if it wasn't the operative cause of the loss of Church Road. I hope we all understand that. That's the analysis we have to apply. Similarly, when it comes to the second question about whether it was reasonable to continue to occupy that property, ultimately that doesn't matter if, again, the operative cause wasn't a deliberate act by Mr. Cifci. It could have been perfectly reasonable for him to continue to occupy it, it still wouldn't matter for purposes of intentional homelessness. as it happens, that analysis, as I indicated earlier, gets very clumsy when you haven't got deliberate act to look at. It's not necessarily particularly profitable to do that analysis in my submission. Similarly, in accordance with that submission, and despite what my learned friend has said, and I understand why she put it this way, looking at the provision as a whole doesn't help. It risks skirting over the critical two aspects of causation that are always relevant to a Section 191 case. And in my submission, there lies an inevitable error if we try to do that and crash straight into Lord Reed's very careful analysis in Hiley, which I would commend to the court. It simply doesn't really matter, but for the refusal of Brian, whether he would not have been homeless or might not have been homeless at the point of the date of the application to Sutton, if one can't hook the loss of church accommodation on the refusal of Brighton Road for reasons I've explained earlier, in my submission, you simply can't do that. Just one quick point as an aside, on the point about the nature of the offered-on accommodation, whether or not Cifci would still be homeless at that point in time. First of all, it's not relevant. The nature of that accommodation in my submission just doesn't fall into the analysis. But for what it's worth, it's probably the case that Mr. Cifci would have been at that point threatened with homelessness rather than actually homeless.
Well, because he was told you can only have this until such and such a
28
date.
days, and significantly that's less than the 56 days that is the window for threatened with homelessness, see Section 175, subsection 4, Authorities Bundle, page 123. So all of that being said, of course, one must look at the specifics of this case and the facts of this case. And fundamentally, the London Borough of Sutton wrote the answer to this case in black and white in the decision on the 17th of January. They told everybody why Mr. Cifci was being required to leave that accommodation, and it plainly wasn't because of the discharge of duty decision, because they proposed to carry on accommodating him. I mean, with respect to my own friend, she doesn't really engage with that black and white fact. Important to note, however, that at one point my learned friend characterised the appellant's case as being one where we say that he left because of the notice. That's true in a sense. To be absolutely clear, our case is he left because the London Borough of Bromley told him to leave. But the reason the London Borough of Bromley told him to leave was because of the notice. And those are the facts which are incontrovertibly true, unavoidably so in my submission. My learned friend also says that, well, notice wasn't acted upon. It certainly was acted upon. It was acted upon by London Borough of Bromley in the ways that we have been looking at. So, for all those reasons, in my submission, the disciplinary approach does only produce or generate one answer. But can I, so as not to be seen to be trying to avoid these issues that might arise as a consequence of this court returning that answer in this case? I do so, though, with a cautionary note at the beginning that we are dealing with causation, we are dealing with hypothetical scenarios, and it's very dangerous to try and extrapolate too far as to what the implications might be here. I don't necessarily accept it's helpful to do it at all, but that being said, let me try and make a couple of points if I can about it. Fundamentally, a lot of the time, in a scenario such as this, and the one that's been posited by my own friend, is where there is an independent reason why a particular unit of accommodation should cease to be made available to a particular applicant at a particular point in time. And I believe the premise is that the applicant shouldn't in any way be to blame for that set of facts. The first point to note is that a lot of the time in those scenarios, it will be in the local authority's gift to do something about that. My learned friend actually spoke briefly about the local authority's stock, the accommodation it either owns or has some form of proprietary interest in, which it often does through a lease or a licence, which it is to some extent in charge of. And in those circumstances, of course, one has to anticipate that the local authority will take the steps necessary to avoid somebody becoming homeless. Indeed, that's exactly what Bromley did to some extent in this case, sought to make an offer on the eve of homelessness, as described in the offer letter of Brighton Road. There will, of course, be cases, perhaps more likely where third parties are involved, like third-party landlords, where an external force is basically dictating the outcome to everyone. for what it's worth, that's what London Borough Bromley treated the landlord's notice as in this case. We know that. I reference to everything it did. It's speculative for anyone to ask or suggest whether that was necessary or not. We simply have no idea. We don't know what those relationships were like between the London Borough Bromley, that particular managing agent, and the particular landlord. All we know is both the managing agent and the landlord said effectively there's nothing that can be done about this particular case. Nothing to be done perhaps about the notice, but it's important to keep in mind that Bromley had over 8 weeks, nearly 9 weeks, to do something about this problem, and they waited until the afternoon before homelessness arose. That can't be ignored if one is going to look at the overall circumstances or implications of a finding in favour of Mr. Cifci in this case. It was perfectly within London Borough Bromley's gift to do something about it. There's no evidence to suggest it was prevented from doing so.
What might it have done other than making an offer such as it did?
Or make the offer much sooner than the eve of homelessness.
Now I see that. And what difference would that have made?
Well, for example, if this played out and Mr. Cifci had refused the same offer of accommodation, he'd been given 28 days' notice to leave before the notice expired, there wouldn't be any question at all of him being unintentionally homeless. He would plainly be intentionally homeless.
Why is that?
The reason he'd actually believing at the time was because London Borough Bromley were no longer prepared to pay for another night accommodation for him. So imagine a scenario where this all plays out in the first couple of weeks of the notice, again with all the health warnings about speculating about hypotheses, and Mr. Cifci refuses Brighton Road. They say he can have 28 days, and those 28 days expired, let's say for the sake of argument, on the 21st of December. And he left on the 21st of December because London Borough Bromley said, you've got to leave because we're not going to provide you with another day's accommodation. Why? Because we discharged our duty. Why? Because you refused the offer. Clearly intentionally homeless. It's not the fact only of the notice, which means Mr. Cifci's case succeeds. That's the implication my learned friend invites his court to accept. That's not correct. The key point here is London Borough Bromley, in light of the notice, decided that even though they wanted to continue to accommodate Mr. Cifci, could no longer do it at 22 Church Road. They'd run out of time to do it on their own case, on their own analysis of the facts. And we are all stuck with that. But it doesn't mean every landlord or every local authority, I should say, is stuck with that scenario. There might be multiple ways to avoid it. I don't know, even potentially negotiating with a landlord, who knows? But we can't, it's not the mere fact of there being a notice that necessarily makes it inevitable, but irrespective of what happens, a person such as Mr. Cifci can never be found intentionally homeless. I've just given you a clear example of how he would have been.
So just thinking through one of Ms. Screech-Powell's examples,
Yes.
you have a family who've been accommodated in large accommodation because there are lots of children, whatever. The children all go away. The local authority thinks, well, can't leave them there. We have people who need such large accommodation. So we are going to require that family to leave the large accommodation and we are going to offer them something smaller elsewhere.
Yes.
And that's turned down. So how does that work?
What, then they subsequently decide that the family need to leave the property there
And they do indeed. I mean, they were always going to require the family to leave. They do, in fact, require the family to leave now in circumstances where their duties come to an end.
Well, that's just a classic scenario where the council's in charge of its own destiny. I mean, it's in a position to say, we've made our own operational decision that we'd like to take this family out of this under-occupied accommodation, give them accommodation which is better. We offered them something better. They refuse it, and they turn around and say, well, we're not providing you with any more accommodation anymore. You've had your opportunity to accept reasonable accommodation, and the reason we're actually asking you to leave this accommodation now is for that fact.
But does that work? I mean, they've decided this family is to leave this accommodation. So whether the offer was accepted or not, the family was going to leave the accommodation.
At a point of time of the council's own choosing. I mean, that's
no, quite. It's a point of time of the
difference.
council's choosing. So they decide they want this property back now.
Yeah.
That's going to happen whether the offer's accepted or not.
Well, it might be a question about when it's going to happen. I mean, again, I think it gets quite difficult. I mean, and my learning friend relies quite heavily on this idea that there's a duty extant or being fulfilled at the relevant time. I actually, my submission don't consider that to be relevant. I was going to come on to explain why that's so in a moment. But on any view, it might help to think about it in this way, that the council itself either feels there is a, if you like, external force, whatever it is, driving an outcome that it can do nothing about, in the sense of avoiding that outcome, but it may have some time to do something.
Yeah.
And in that time, it may well get to the stage where it's exhausted all the things it needs to do and can legitimately turn around to the family and say, yes, we can see that you're going to end up being made homeless by this scenario, but we've done all we can do and have to do in this particular situation. Doesn't preclude an application being made later on, I should add, but it certainly doesn't necessarily mean they'll be found to be unintentionally homeless. That's why this case is quite different.
So hang on, that's a scenario where there's an external force, but I think you were going to come on to the internal force, or weren't you?
To me, the internal cause is just not a fair analogy, because how can it possibly be the case that if a council itself allows someone to become homeless because of their own, frankly, negligence in discharging their own management functions in relation to particular families, to then say, well, we think that you're intentionally homeless. You can't be intentionally homeless simply because you've refused an offer. So this scenario posits a situation where the actual cessation of occupation at the particular time in which it happens is because of a fact that the council don't feel they can do anything about. Whether that's if that's its own decision about how to manage its own stock, then by definition we're not in that scenario. I mean, with respect, it would be very bizarre were we to say that Mr. Cifci can't succeed in his case because there might be scenarios where landlords, the councils themselves, feel for property management reasons they need to move somebody, and then they allow that person ultimately to get to the point where they have to move them in circumstances where they're still proposing to carry on accommodating them, which is our case. And it's very difficult to see how they would be intentionally homeless in that scenario. But it's getting, if I may say so, speculative to several degrees away from this case. It's not necessarily very helpful. The point I'm trying to convey is even in the scenario where there's an external force, if you like, which is plainly how Bromley treated the landlord's decision in this case, there may still be a window of opportunity for the council to do something. And that may be sufficient time for them to get to the end of the road completely and say, well, it's not, we're not stopping accommodating you because of the external force, we're stopping accommodating you because we no longer have to accommodate you anymore. That's not our case.
Well, I'm a little confused about that because at one level you're saying the Sutton properties are relevant, but in another main you're positively relying on it to say they were proposing to continue to provide occupation. So what do you say is the relevance or otherwise?
I was suggesting that the nature of that accommodation was irrelevant, is the point I was making.
But it's only offered when they've discharged their housing duty.
Yes, but for our purposes, the relevance of it is straightforward. It's on the day that they're asking them to leave, is it because of the discharge of duty? And it's not, because despite the discharge of duty, they were still proposing to accommodate them, and indeed would have done at Church Road. This is the incontrovertible aspect of this case, which in my submission makes it somewhat unusual and not the norm. And having made that decision, they're faced with the facts that, frankly, they've run out of time and they've got to face the fact they've got to provide them with accommodation elsewhere. But it's just not possible to say that the reason why they asked them to leave on the day that they asked them to leave is because of the discharge decision.
Okay, if they had said, right, possession order hasn't come along, you can stay in Church Road for another 28 days, that starts to be closer to one of your hypothetical
Absolutely,
examples.
It does.
What you're relying on here is the very clear statement, you've got to get out because the landlord's insisting on it.
Yes, I'm relying on the actual cause of the cessation of occupation referring to Church Road. And we can speculate about different hypotheses as much as we like, but we're not allowed to allow that to determine the answer to the straightforward question of causality. I'm at some pains to try and, if I may say so, dampen down what my submission was an exaggerated attempt to say this is going to be very problematic for the Act, and I think my submission is not going to be. there were options available to Bromley, and there would be options available. Doubtless, there are often options available to local authorities who are told by particular landlords, you know what, we'd like these units back. Can you make arrangements to ensure we can have them back when we need them?
With the snag, of course, that if you want to manage the property available to you efficiently, given the demands on you, you don't want to give up accommodation that you've taken on earlier than necessary.
Well, that may well be
Because
so.
then you get a void,
There are well,
or may get a void.
my lord, why this does get very difficult is the manner in which local authorities discharge their obligations to people in terms of provision of accommodation is, and on this bit I definitely do agree with the case, enormously complicated. I mean, my lord, I've appeared before you in a case that was very much about how complicated this can get. And it's really difficult to start looking at that as if it's a fixed mechanism or a fixed set of processes and extrapolate out from that. There's just no reason to do it, in my view. You can just answer this case on the black and white letters that London Borough of Bromley provided you with. It doesn't have to have any implications beyond this particular case, other than to potentially say local authorities might need to be a bit careful if they really do think we can't do anything about an impending episode of homelessness that's going to be completely unintentional, that they might want to try and do something.
You can't help feeling that if we allow your appeal, this may feature again.
Well, in my submission, I'm not sure it would, but I would make one point, which my learned friend I think was making at the end and conceding, which is, let's imagine this wasn't a duty case. This was just a private landlord saying, I want my property back. My learned friend seemed to be prepared to accept in this scenario that there would be no issue. That despite the refusal of the offer, the family are...
Well, sorry, I think the premise was there wouldn't be any need to make such an offer until they were...
No, not at all. They could apply on the basis that they were likely to be homeless imminently. The local authority may seek to make them an offer beforehand. That offer might be refused. They might subsequently become evicted from their actual property for reasons that are entirely unconnected to their own culpability, and they won't be intentionally homeless. And indeed, that is exactly the facts of the Kensington versus Ealing case. And Ealing said, well, wait a minute, we discharged our duty to this local authority before, to this individual before, that must mean we can't be fixed with a duty to provide accommodation, and the court said no. Slightly complicated by the fact that Kensington Council were the council that made that decision, but Enfield weren't able to turn around and say, well, you've reached clearly an unlawful decision on intentionality. Didn't even try and argue that, actually. I don't necessarily think I can say anything more about the broader implications other than to invite the court to decide this case on the particular facts. What you are doing in doing that, of course, is following the same disciplined approach of Lord Justice Lewison in December and other cases, which in our submission is imperative. I'm going to turn my back.
Please.
Well, my lady, my lords, if there's anything else I can say.
No, I don't think there are any more questions. So, thank you very much, Mr. Burton. Thank you very much, Mr. Screech Powell. Thank you those also who haven't had speaking roles, at least in this court. You won't be surprised to know that we're going to reserve our judgment. You will be supplied with it in draft in the normal way for you to correct our typing in English, but not obviously so as to re-argue the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, could we have brief written submissions, and we'd expect to settle the points in the order that we make. And then finally, I ought to remind you of what you will already be well aware of, and that's the importance attached to the embargo. I think you've already given us a list of those who you think should have the draft judgment. Were you to think of anybody else who ought to have it, then plainly you need to come back to us, given the significance of the embargo. But thank you all very much.
Court, right?